Jackson Allen Grimm. Please announce appearances.
Jared Regier on behalf of the state.
Susie Locke on behalf of Mr. Grimm. I see that his mom is present, but I'm not sure that he is present. Oh, he's present with his mom. There we go.
All right. And so, Ms. Locke, you said that he's already entered a plea to the failure to yield at a stop sign and failure to provide damage, but I think I've seen some of your concern. I don't know if it was an email or a motion, and without all of my court file, because of our computer system, I don't have everything here, but why don't you proceed with your motion?
Yes, Your Honor. So my client did not actually enter into a plea agreement. What occurred on or around August 17th was that his mother called the district court and requested a pay or appear date, essentially wanted to clarify when that was. What the court apparently took that as was her entering into a plea agreement and essentially entered a plea agreement. The charges of the ticket are contested, and they're contested in a civil matter. So it is significant that this was allegedly a plea agreement. And so we are asking that the court set this aside, which is consistent with KSA 223210, which allows the court to set aside a plea agreement to correct a manifest injustice. Ms. Grimm had no authority to enter into a plea agreement. She was not a party to the case. It was not even her intention when she called that she enter into a plea agreement, but somehow that is what occurred.
When you say the court, was it actually the judge, or was it someone in the clerk's office?
My understanding is that she had a conversation with someone in the clerk's office.
Correct. And failure to provide the DMV with change of address or name within 10 days, isn't that an A misdemeanor?
Your Honor, my understanding is that, one moment. Your Honor, my understanding is that a violation of KSA 8248 is an unclassified misdemeanor. In any event, my understanding is that the matter is set for evidentiary hearing, and while Ms. Locke does appear to make certain allegations in the motion, my understanding is that there have not been any facts entered into evidence consistent with those allegations.
Well, let me just make sure I know what we're dealing with. I don't know why I thought that was an A. Notice of change of address 8248. That's it. Okay. So that's a must appear. Would counsel agree that's a must appear, being a misdemeanor, so that the clerk wouldn't have had authority to accept a plea?
Yes, Your Honor, he was set for a court date, and his mom called to determine what exactly that date was, and that was somehow construed as a plea agreement. And okay. We appeared on this matter previously, but my client was called into work and was unable to appear. So the court requested that he and his mother be present at the hearing to take testimony. They are here, but I can tell the court that their testimony is going to be consistent with what we've said today on the record as a proffer and what was in the motion. But both of them would stand for questions if the court or the prosecutor's office has questions. I truly think that this was just an unfortunate miscommunication in the clerk's office. And we really would just like whatever alleged plea was entered into set aside so that this matter can proceed.
Okay. Mr. Regier, your position on what's been alleged here?
Well, Your Honor, At the risk at putting the cart before the horse, the state is prepared to proceed to legal argument on this point. I will note, at least preliminarily, that the notwithstanding the allegations being made by counsel for the defense, Kansas case law makes it very clear that the only grounds for permitting the withdrawal of a guilty plea are after sentencing are showing a manifest injustice under the Oliver and Atterbury cases from 2008 and 2010, respectively.
Right, so, but you're not denying the factual allegations, Mr. Regier, or are you?
Your Honor, I can neither speak to those since no evidence has been presented as to either of those points, Your Honor.
Well, you know whether or not your office entered into a plea negotiation with the defendant. Would you not know that?
Your Honor, my understanding is that no journal entry of misdemeanor and conviction and sentencing was filed in this case. And indeed, based off of my notes, the first hearing in this matter was October 11th, which would appear to be at the point at which the motion to set aside plea was heard, or at least as a preliminary matter.
All right, I don't think there's a factual dispute here, but Ms. Locke, go ahead and call your first witness, if you would, please.
Yes, Your Honor. The defendant would call Michelle Grimm.
Okay, Ms. Grimm, please raise your right hand. You solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please proceed, Ms. Locke.
Ms. Grimm, please state your name for the record.
Michelle Grimm.
What's your relationship to the defendant in this case?
I'm his mother.
Ms. Grimm, did you have reason to call the Butler County Judicial Center on or around August 17th, 2023?
I did. I was calling to get information on the ticket and to find out what our next steps needed to be.
And as a result of that phone call, what did you understand the next steps to be?
That we either needed to ask for a 30-day extension, or request a court date.
And what did you do at the end of that phone call?
I stated that I needed to talk to my son, and then we needed to talk to his employer to find out what to do next.
Did you learn anything after your phone call with the clerk's office that caused you to question what they told you on that day?
Yes, I actually did. I called back and I can't remember exactly. I think it was I had asked for that we wanted to go ahead with the extension because they told me if we didn't do that, then there would be a warrant for his arrest based on no payment. So I said, well, that's what we wanted to do. And then when I called back, I learned that that was not done for us.
And at that time, did you understand that some sort of disposition had been entered on the case, meaning that something had happened in the case to show that your son agreed to the charges?
No.
Okay. Did you have authority from your son to enter into any agreement related to how the charges would, whether or not the charges would be accepted by Jackson Grimm?
No, I just was getting information for him since he couldn't call from work.
Okay. Your Honor, I don't have any additional questions for this witness.
Mr. Regier, cross-examination.
Just one question, Your Honor. Did you execute, and when you allegedly contacted the clerk's office, did you execute any written documents?
No.
No further questions, Your Honor.
Redirect.
Nothing, Your Honor.
Your next witness then, Ms. Locke.
The defendant calls Jackson Allen Grimm.
Are you Jackson?
Yes.
Please raise your right hand. You solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth. So help you God.
Yes.
Thank you. Please proceed, Ms. Locke.
Mr. Grimm, did you provide your mother authority to enter into a plea agreement?
I did not.
Did you enter into a plea agreement?
I did not.
Have you ever had any conversations with the prosecutor's office in Butler County, Kansas?
No, I never called them.
Did you file a no contest plea to the charges in this case?
I don't think I filed any plea.
Are you asking the court to set aside whatever alleged plea was entered into?
Yes.
Are you asking the court to set this matter for a control hearing so that it can proceed to trial on the allegations made in the ticket?
Yes.
No further questions for this witness, Your Honor.
Mr. Regier, cross-examination.
Did you execute any written documents of any kind during the course of this matter?
No.
No further questions, Your Honor.
Mr. Graham, how old are you?
I am 20.
And your mom's not a lawyer, or is she? All right, thank you. Ms. Locke, further evidence?
Nothing further from the defendant, Your Honor. I will state that I have never seen a document that was executed by my client that would be a no contest statement. I have not been provided anything that would demonstrate that he, in fact, entered into any sort of agreement with the prosecutor's office, only the statement that such a plea had been entered into.
Very well. So Ms. Locke is apparently resting this motion's evidentiary portion. Mr. Regier, any evidence from the state?
None from the state, Your Honor.
All right, any arguments, Ms. Locke? All right. Anything additionally than what you've already told me?
Your Honor, Mr. Regier cited some case law earlier, suggesting that the plea could only be set aside for manifest injustice. However, Mr. Regier does not have a signed plea agreement with my client. It doesn't appear that this court ever took a plea on these charges. So we feel like it is manifest injustice to just enter into a plea saying that someone pled no contest to a ticket, which in fact they do contest. And it's clear from the record today that neither my client nor his mother intended that to occur or ever believed that that had occurred. So we are asking the court to set aside the no contest to the ticket and allow this matter to proceed forward.
Thank you. Mr. Regier, now do you have any argument?
Yes, Your Honor, if the court will permit me.
Certainly, go ahead.
Your Honor, pursuant to the paragraphs 2 and 3 of the defendant's motion to set aside plea, it appears the crux of the argument is an ongoing civil suit. Certainly manifest injustice is the statutory standard here, which is solely a matter of the trial court's discretion with the burden of proof relying on the movement under the Kelly and Solomon cases. As previously indicated under State v. Oliver and State v. Atterbury, the only grounds for permitting the withdrawal of a guilty plea after sentencing is manifest injustice. However, notwithstanding the defendant's allegations, manifest injustice is not an umbrella term to throw around against all possible consequences or convenience, but is specifically defined under Kansas appellate case law. In State v. Oliver, the Kansas Court of Appeals determined that to successfully make a showing of manifest injustice, the appellant had to demonstrate to the district court facts showing that it would be obviously unfair or shocking to the conscience not to permit him to withdraw his plea. This specific definition was subsequently upheld in State v. Atterbury, another Kansas Court of Appeals case from 2010, specifically quoting a prior one, State v. Barahona from 2006. Here it is the state's position that the defendant has failed to make a showing of how any of the alleged events concerning the defendant or the defendant's mother rise to the level of something obviously unfair or shocking to the conscience under the applicable case law. Not only has the the resolution of traffic of cases prior to the time specified in the notice of appeal by payment in any matter accepted by the court been specifically authorized by the Kansas legislature under KSA 82118 subsection B. Again, the crux of the defendant's argument seems to pertain to some alleged ongoing civil litigation. In this case, however, the witnesses have both testified that there were no written documents executed in this matter. So it would appear that this particular case specifically falls under KSA 82118 subsection B, which provides, quote, when a person charged with a traffic infraction makes payment without executing a written waiver of right to trial and plea of contest or plea of guilty or no contest, the payment shall be deemed such an appearance, waiver of right, and plea of no contest, i.e. nolo contendere. And under State v. Holmes, a plea of nolo contendere, unlike a guilty plea, may not be used as an admission in any other action based on the same act. Accordingly, it is the state's position that the arguments raised by the defendant in the motion to set aside plea and here today concerning the alleged civil litigation do not rise to the level of obvious unfairness and shocking the conscience required for a finding of manifest injustice and consequently the withdrawal of a plea after sentencing. And for those reasons, the state respectfully moves to the court to deny the motion to set aside plea.
Your Honor, may I respond?
Please.
Mr. Regier cites significant case law that relates to an individual entering into a plea agreement. My client testified here today, and so did his mom, that he never did that. He never consented to a plea agreement. And any sort of payment of a fine was done by his mother after hearing from the court that a warrant would be out for her child's arrest. She didn't have the authority to enter into a plea agreement, as stated by her on the record. And my client stated very clearly that he did not give her that authority, nor did he have that intention. So while I appreciate Mr. Regier's statement of the law, to take and not set aside a plea agreement that was never entered into by the party that is subject to the plea seems like manifest injustice. So we are asking the court to set aside the plea, whatever that happened to be, and allow this matter to proceed to a control hearing. And we don't believe that the state in any way is setting a precedent or would otherwise have any sort of disruption to their normal course of business by allowing this young man to defend his case.
Well, I think that we could clearly draw a distinction between the defendant taking it upon himself to pay the charges and costs and his mother doing it, particularly if she did not have his authority. I would have liked to have heard the clerk's position on this, but I didn't. So with what the evidence before me tells me, and without controversy, is that the mother paid the ticket unbeknownst to the juvenile. The tickets being for fail to yield at a stop or yield sign and failing to provide the DMV with change of address or name within 10 days. The first one being an infraction and the second one being a misdemeanor. As Mr. Regier pointed out, there was an injury crash according to the notes of the officer on the ticket. And that does seem to be some motivation in the motion today. But for a third party, even if that third party is related to a defendant, to be able to go in and pay a ticket for someone without someone's authority certainly seems shocking to this court's conscience, and to not allow the pleas to be set aside would amount to a manifest injustice. Now, again, had he done that himself, I would say, you know, you're bound by that. But he didn't, someone else did. He's 20 years old. He's an adult. He should be thinking for himself and taking care of his business. I don't know why his mother was in the middle of it anyway. But she was, and if she didn't have his authority, then he shouldn't be bound by what she did. I'm also troubled by the fact that this one is a misdemeanor, and I know that for a long, long time, there were certain misdemeanors, including no proof of insurance, that individuals could go into the clerk of the court and pay without setting a trial date or a hearing date. But the Office of Judicial Administration within the past year or so has made it clear that if they're misdemeanors, they should have a court date. So I'm also concerned why the mother was allowed to even pay that ticket without setting it for court. Nevertheless, at this time, I do find manifest injustice exists to set aside the plea to both of these tickets and proceed to put them on the docket at this time for further disposition or hearing. Is your client wanting a trial on these tickets, Ms. Locke?
Your Honor, we asked the court to set it for a control hearing so that I can have further conversation with the prosecutor's office related to the tickets.
All right, do you want to do that on a Monday morning when we usually have these types of cases with attorneys?
Yeah, I have no objection to that, Your Honor.
All right. Ashley, do you have something on a Monday morning short of March 20th or March 10th, isn't it?
I don't know what the Mondays look like before March the 11th. That was the date that I was given.
Oh, is that what we were using, was March 11th? I
Yes.
thought it was used for 10th. All right, we're going to set this for 9 a.m. on March 11th for status or control. And then at that time, I'll either expect some type of disposition or trial setting so that we can move these charges along. Anything else we need to address? I would expect Ms. Locke to journalize today's findings.
Yes, Your Honor, nothing from the defendant.
Anything further from the state, Mr. Regier?
Nothing from the state, Your Honor.
All right, we will be in recess.